The enemy of my enemy is my friend. In a shocking turn of events, we have both the defendant and the plaintiff in a major commission lawsuit uniting against the Department of Justice. So let's read. This one's pretty juicy. I like this one. It's a good story to end the week on. All right, so let's dig into this. Defendant and plaintiffs in Nosalek Commission case unite against the Department of Justice. Oh, and by the way, this article is courtesy of inman.com, so go check them out. Defendant MLS PIN, so it's the MLS PIN. You're going to see something unique about this particular case here shortly. And plaintiffs, Jennifer, and the defendants, asked a district court judge for permission to respond to a statement of interest the DOJ filed in the case. So this was a case that we talked about, or a filing that we talked about earlier on in this channel, about this whole decoupling of commission. So the Department of Justice came in and said, hey, at this point, the buyers, we want to prevent the sellers from actually essentially paying for the buyer's commission. So let's go ahead and make that a ruling right now. So let's decouple the commissions and let the buyers negotiate with the agents directly, which is something that's been happening for a while. But anyway, that's the backstory there. So the plaintiffs and the multiple listing service defendant in a major antitrust commission suit are joining forces against a common foe, the U.S. Department of Justice. Imagine that. That's pretty interesting. On Wednesday, plaintiffs Jennifer Nosalek, and I don't really like reading too many of the plaintiffs' names, and defendant MLS Property Information Network, so this is up in Massachusetts, asked the U.S. District Court for the District of Massachusetts for permission to respond to the statement of interest in the Department of Justice filed in the case February 15th. So it's something we talked about, February 15th, so we're talking about 2 weeks ago. So if you're curious to see what that take was, check out the previous videos on this channel since we talked about the whole decoupling of commissions. In that filing, the federal agency rejected rule changes in a proposed settlement between the plaintiffs and the MLS PIN and instead called for an injunction, this is the important part, an injunction that would prohibit sellers from making commission offers to buyer brokers at all. So while both the plaintiffs and the defendants were basically had an agreement of what needed to happen, well, the Department of Justice comes in like the Kool-Aid man and says, hold on right now, let's go ahead and do this. In other words, creating law basically is what's happening here. Therefore, promoting competition and innovation between buyer brokers because buyers would be empowered to negotiate directly with their own brokers. Now, we have a stance already on this in terms of why this particular framework would put buyers, especially ones that don't have as much money cash on hand, would put them at a disadvantage. We've talked about that extensively and what these commission lawsuits mean altogether. I think this is actually the first video that we ever made on this particular channel back in January. So you're going to want to go and check those out. I just wanted to cover this particular article because it was very interesting in a shocking turn of events. While the plaintiffs and the MLS PIN have previously gone back to the drawing board, let me start that again, because while the plaintiffs and MLS PIN have previously gone back to the drawing board and rejiggered their settlement after the DOJ expressed their concerns about the deal, it seems that after hearing the antitrust enforcer's specific objections, they have decided instead to fight. So again, we had the plaintiffs and the defendants. At this point, they had already come to an agreement or a settlement agreement. The Department of Justice comes in and says, no, let's do it this way, or actually, you're not gonna be doing that. And and the plaintiffs and defendants went back to the drawing board, as it is saying, and started reworking it to essentially satisfy the Department of Justice. As they were reworking it, or the settlement, as they were reworking that settlement, they said, you know what? No, we're not gonna be doing that. So instead, they decided to go against the Department of Justice and are looking to file some arguments. So plaintiffs and MLS PIN dispute the factual and legal arguments, so both the facts and the legal arguments made in the DOJ's statement of interest. Attorneys for both say in a joint court filing. Accordingly, plaintiffs and the MLS Penn respectfully request the opportunity to file separate responses to the DOJ settlement of interest no later than March 28th. So they're not completely combining every effort to go against the Department of Justice. They did file that. They did file that joint filing so as to ask for permission for each one of the parties, the defendants and the plaintiffs, to respond. And then it goes on when oral arguments are going to be made. But I wanted to share a little bit of the differences between this particular lawsuit versus the ones that we hear about all of the time. Like federal commission suits, Morrell and Sitzer Burnett, Nosalek seeks class action status and alleges that the sharing of commissions between listing and buyer brokers inflates seller cost and is a conspiracy in restraint of trade, a violation of the Sherman Antitrust Act. So basically the same arguments that these respective lawsuits have already been making. Now here's what's different about this particular case. However, Nosalek differs in one important respect from many of the other suits. The National Association of Realtors, so NAR, is not named as a defendant. This is one of those rare instances. There's only a handful across the country that actually don't name NAR. While MLS Penn is, the MLS, which has a full-time staff of 60 employees, boasts approximately 46,000 subscribers in 6 New England states and New York. So 46,000 agents is quite a massive quite a massive subscriber base. As a point of reference, here in the Dallas-Fort Worth Metroplex, one of the major ones that we have here is Metrotex, and I believe they're at 28,000 members, if I remember correctly. So when it comes to this particular suit, again, one of the main differences here, one of the differences is the fact that in this particular lawsuit, they're just looking at the MLS. At this one MLS, they didn't even pull in the National Association of Realtors, and they also didn't pull in other brokerages. It was just that specific MLS. Now they're asking for the same things, they're making the same arguments, but in this case, they're not naming NAR. And as we know, NAR at this point, to date, has been named in about 22 lawsuits right now. Most of the commission lawsuits at this point. So again, there's only a handful that I'm aware of that actually don't include NAR. Whether the plaintiffs and MLS Penn will specifically oppose the Department of Justice call to the couple commissions remains to be seen. So we don't necessarily know what these, although they're teaming up right now, the plaintiffs and the defendants, we don't necessarily know what they're going to be saying in those separate statements. A week after the Department of Justice filing, NAR broke its silence on the agency's proposal, stating it would harm consumers by making it more costly for home buyers, we just talked about, for home buyers to get capable representation and by reducing access to fair housing. So NAR has responded to this, other brokerages have responded to this, and most of the brokerages and their representatives have responded to this this whole Department of Justice decoupling thing, because that was a pretty big deal in the way that they were going about it and just going straight for the jugular. But anyway, let me know what you think. Is this going to be a good thing? Is it going to be a bad thing? Is this just a temporary thing? Let me know down in the comment section, and I'll see you next week.